you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you're not sure what your workplace rights are, this is the show for you. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Every week, we examine myths and clear up confusion about your employment rights in Canada and how to get advice and compensation you need. Employment lawyer Lior Sampiru is here once again, co-founding partner at EmploymentLawyer.ca. Before we get to today's questions and phone calls, Lior, why don't you tell us why you believe it's important that every Canadian understand their workplace rights, and tell us about a significant case you had this week.
Great to be back here, Dana, to talk about employment law. And every week when the show airs, I have people call or email me telling me that what we talked about answered questions that they had or informed them about something they were always wondering about. Well, that's exactly why we're here and why this show is important and why it's so important that everyone understand employment law. It is such a vital aspect of what we do. And hopefully other aspects of law, criminal law, hopefully is not something that's going to impact us too much. Corporate law, even real estate law, maybe we buy a house once or twice in our lifetime. But employment law is something that impacts us daily and all the time. And so many people walk around having jobs, not understanding what their actual rights are. I think that's wrong. That's why we're here, and I'm so happy to have this opportunity in this forum to talk to people and inform and educate about such an important topic. So let me give you an example, then, a situation that came across my desk very early this week. I spoke with a gentleman who was employed in Ontario, working from home for about 3 years now. And his company that he works for is based in the U.S., in the state of Ohio. And he's always worked for this company or always worked there, never stepped foot in Ohio, by the way. Recently, company, because of COVID-19, unfortunately, had to let him go, decided that your job is no longer necessary. And they said, we're an American company, we're going to follow Ohio laws, and we're going to pay you whatever severance is based on Ohio laws. And by the way, that severance is nil, because in the U.S., they have something called at-will employment, which essentially means you can be let go and get paid nothing. So this person really wanted to understand, well, I work for an American company in Ontario. What are my rights? Here's the thing. It does not matter where the company is located. What matters is where you're based out of. So if you work in Ontario, it's Ontario laws that apply to you. And that is a huge thing when we're talking about American companies, because unlike our neighbors to the south, we have much, much better employment laws in Canada. We have extensive laws, including with respect to severance. Whereas in the U.S., he could have been let go and got nothing. Here he's owed about 6 months severance. So I wanted to remind everyone that it does not matter where the company is based. It doesn't matter where their head office is, where the HR office is. It matters where you're physically located. And if you're physically located and work in Ontario, it's going to be Ontario laws that apply, and that is a very good thing.
Okay, you can connect with employment lawyer Lior Sampiru directly by going to EmploymentLawyer.ca or calling 1-888-861-4555. Let's get to our first call of the show, Lior. These calls come into your radio show that's across Ontario and Canada, where you take live questions from callers. Let's take a listen.
I'm in the automotive field. I've been with my employer for 23 years. I was brought in last Thursday, and just for the next long weekend, I'm told that my service no longer be rendered.
How old are you, Greg?
I just turned 48.
What did they offer you?
They're offering me 1 week for every year.
So 23 weeks pay?
That's correct.
What was your job? What did you do there?
I was a supervisor at 65 employees under me.
This is such a common scenario. I get calls and emails like that multiple times a day. Every single day, someone has been let go, they've been offered something, and guess what? It's not even close to being adequate. Well, let's start with the idea that despite him may not having done anything wrong, the company is allowed to let him go. It's a question of compensation, a question of severance. We know he's been there for a while, over 20 years. He was offered a week per year of service. For him, that's 23 weeks. The question is it adequate? It's not even close to being adequate. And rather than me just tell you, here's how much he's actually owed, let me show you how much he's owed. And you can do the same thing at home. You can go to our severance calculator. It's pocketemploymentlawyer.ca. That's how you find it. Again, it's pocketemploymentlawyer.ca. And you can find out and calculate your own entitlements. Let's take this person's scenario, let's plug that in, and let's see what we get. Let's see how much he's actually owed. So we know he's been there for 23 years as a supervisor at the age of 48. We know he was offered 23 weeks pay. Bad. How bad? You can see right at the bottom of the screen that he's owed as much as 22 months pay. Offered 23 weeks, owed 22 months. I did some math here just for fun. If his salary is $76,000, that's a difference potentially of as much as $150,000.
Wow.
Now, we didn't bring this up here because it's such a unique and crazy scenario. We actually brought it up because it is a common scenario. You may not be owed $150,000, but you could be owed $25,000 or $50,000. It's so important to get advice if you lose your job. Short service, long service, senior or junior employee, just as important.
Okay, let's take a quick break. And when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will delve into more common employment law questions. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is taking your employment law questions. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or go to employmentlawyer.ca. We have more calls and questions coming in, but before we jump to those, let's talk about today's main topic. Okay, Lior, the most common law questions you are asked. Question number one, I didn't do anything wrong, can my employer fire me?
You know, that is the number one question, the most common question. People often tend to call my office when they lose their job. And usually it starts with, well, I don't think it's right that I was let go. I didn't do anything wrong. There was no warnings. They just let me go. And believe me, I understand that. I would feel exactly the same way if I was let go in those circumstances. Why should I be let go if I did nothing wrong? I worked hard, etc. I get that completely. But from a legal standpoint, an employer is allowed to let you go for bad reason or for no reason, as long as severance is paid. So an employer does not have to have an actual reason, does not have to share a reason, and if they give you a reason, unfortunately, that reason doesn't even have to be correct or honest or true. They can tell you something that's incorrect. As long as severance is paid, that is legal. The law can't make an employer be honest or be a better quote-unquote person. The law can only make sure that you get the compensation that you're owed if you lose your job. So yes, you can't be let go, unfortunately, even if you did nothing wrong, but severance has to be paid. And in the vast majority of cases, over 90% of cases, when someone is let go, they're not offered proper severance, which makes that situation a wrongful dismissal.
Okay, second on our list of most common employment law questions, how much severance should I get?
Right, that's a nice follow-up to that. So usually when people understand, yeah, okay, I can be let go, they just have to pay me severance. Well, how much severance am I owed? Well, it's not as, it depends, as lawyers like to say. Depends on your age, your position, the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. So no two situations are exactly alike. What I can tell you is that severance is measured in months, not in days, not in weeks, and it can be as much as 24 months' pay. And in the vast majority of cases, you're going to be owed more than you realize and more than what the company offers you. That's why we created the tool, I mentioned it earlier, our severance calculator. You can find that at pocketemploymentlawyer.ca. So if you want to know now how much you're owed, not hypothetically, what's the actual amount that you're owed, grab your smartphone tablet, go to pocketemploymentlawyer.ca, do the calculation. Even if you're just curious, it's a piece of information that we all should have.
Okay, another common employment law question. I tried to come back after disability leave, but was told there's no job for me. Is that legal?
Very common. I'm off work, I'm sick, I want to come back, now all of a sudden there's no work. Can they do that? Well, generally the answer is no. Your employer has to make all efforts to take you back to work. If you are off sick, if you're off on a disability, they need to try to find your old job. If it's not available, find another job that's similar and try to make those efforts to take you back. If the company doesn't want to, they don't try, they're not really looking to bring you back. Maybe they don't want you, they're afraid that you're going to be sick again. That's illegal. That's a human rights violation. You cannot be let go because you're sick. Now, in a situation where there's legitimately no job for you, they've tried, they've looked, there's just nothing there anymore, in that case, they are allowed to let you go with your full severance, of course. In fact, you may be owed even more severance if you're still struggling with health issues. But generally speaking, if your company won't take you back after your disability leave, be very concerned. That could be a human rights violation. You really should reach out to me then as soon as possible.
Okay, fourth on our list of common employment law questions. My employer says they are terminating me for cause. What can I do?
Well, remember, what you have to do is to remember that it's difficult to terminate you for cause. Now, if you know that you did something terrible, something that just makes it impossible to continue employing you, you stole, you hit someone, you committed fraud, well, yeah, guess what? You're going to be let go for cause. You're not going to get anything. But maybe your performance was not adequate. Maybe you were late a couple of times. That's not a good thing. But that does not mean you can be let go for cause. It's difficult to terminate for cause, and most of the times employers pull the trigger on a termination for cause before they should. So you're not sure if it's cause, you're not sure if you're owed severance. Let's talk about it. Give me a call, because you could still be owed your full severance, again, as much as 24 months' pay.
Okay, our last question that your team often hears. My employer put me on a temporary layoff. Do they have to take me back eventually?
My gosh, I've heard that question so many times over the past couple of years because of the pandemic. People have been put on temporary layoffs, so it's easy to assume, well, it's legal because we know everyone has been in that situation. It's not. An employer does not have the right to unilaterally put you on a temporary layoff. If they do, you can treat that as a termination. You don't have to wait for them to call you back. You don't have to sit at home hoping for the best. You can make that decision in most cases. So if you're on a temporary layoff, you can choose to wait. You can choose to treat that as a termination and get severance. If that's what you want to do, happy to chat.
Okay, let's jump to another phone call from one of your radio shows. Take a listen.
The boss has written up new contracts for everybody. Sure enough, I've noticed that one of the provisions in this new contract is me giving up rights to severance. I'm very concerned of that. I have changed my position about 7 months ago. I went from a sales position to the customer service position, and he said this new contract should have been signed when I did change roles. So I don't know if it's kind of like too little too late.
Well, I'm happy that this person took the time to read the contract and understand what they're being told to sign, because it is very, very common. When a new contract is being introduced, one of the reasons for it is to try to limit future severance. Company realizes, man, if we ever have to let this person go, we'll owe them 2 years' pay. How do we reduce that? And they reduce it by having you sign a contract limiting your severance. Don't do that. Don't sign that contract that can cost you tens of thousands of dollars. Anytime you're working, you're happily doing your job, now all of a sudden your employer wants you to sign a new employment agreement, be concerned. It probably limits your severance. It probably gives your employer other powers and rights that they wouldn't otherwise have. Let me see it. I'm happy to tell you what it does. And you absolutely can say no, I'm not signing it. You can't be penalized for doing that. And you don't want to be in a situation where you sign it, and 5 years later, when you're let go, you realize, my gosh, this cost me $100,000. Don't make that mistake.
Okay, you can connect with Lior and his team by emailing ask@EmploymentLawyer.ca or going to EmploymentLawyer.ca. After the break, we'll explain whether you can be let go when you hit 65 and an employee's shock over their alleged job status. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Lior Sampiru from EmploymentLawyer.ca is taking your questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or go to employmentlawyer.ca. We still have lots more to get to, including this call that came into your radio show recently. Take a listen.
Well, it's a situation here. It's actually my wife. She was injured. She went off on long-term disability for over 3 years. She's now reached retirement age. The insurer says, well, you're retired now, so we're not covering you anymore. And the employer says, yeah, you're retired, so this is it. You're gone. 17 years? No questions asked. Sorry, see you. Goodbye.
First of all, this concept, retirement age.
Yeah.
There isn't such a thing as a retirement age.
It's my first question to you, Lior.
See,
What is retirement age?
There isn't a retirement
Right.
age. We got rid of mandatory retirement some 20 years ago almost, maybe 17, 18 years ago. There's no such thing. Now, an insurance company, a disability insurer, is allowed to cut someone off at the age of 65. It's a term of the insurance policy, but that has nothing to do with retirement. The only person that can decide if you retire is you. Company cannot consider you to have retired. There's no such thing as a deemed retirement. And if the company says we're letting you go, well, that's a termination, potentially a human rights violation in this situation. So no, just because she's off on a disability, just because she's hit the age of 65 does not mean she's retired. As long as there's hope for her to get better, to come back to work, if the company lets her go, severance must be paid, potentially other damages as well. So, of course, let's see how much severance she's going to actually have to get, because she hasn't retired, because she is owed compensation if she's let go. Let's go to pocketemploymentlawyer.ca. Let's use our severance calculator once more, and let's see what that gives us. She's in a sales role, been there for 17 years, 65 years of age, as we've just heard. Company's not offering anything because they're saying she's retired. Nonsense. She's not retired. She's been terminated. You see on the screen, she's owed as much as 24 months' pay. Given the fact that she's been there for a while and she's an older employee, that's how much she's owed. Same with you at home. If you're ever in that situation, you can decide if you retire. You can decide if you resign. No one else can decide that for you.
Okay, let's look at another situation that your firm encountered recently. Here's an email. I worked as a project manager for a decade before being fired due to lack of work. I was full-time, paid into benefits, and worked in my employer's main office. When I was let go, they said they didn't owe me anything because they always considered me a contractor. Can they just decide to do that?
This is something we talk about often on the show and I deal with often at the office. It's a situation where he's been misclassified. He's an employee, he has a job, he goes to work, he comes back home and goes back the next day and does it again. He's an employee. It doesn't matter what the company calls him, doesn't matter what piece of paper he signed, doesn't even matter how he pays his taxes, because he's an employee and the law can only decide that, no one else can. And why is that important? It's important that now, after all these years, he's been let go. Because he's an employee, severance has to be paid. A company may think, well, we don't pay you because you're a contractor. Nonsense. He's owed severance like any employee. If he doesn't get it, that's a wrongful dismissal. Potentially, by the way, he could be owed outstanding overtime, vacation pay, holiday pay. So he really needs to connect as soon as possible.
Okay, let's take a quick pause. And when we come back with Lior, partner at EmploymentLawyer.ca, we will address ignored overtime and increased workloads. Stick around. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Lior Sampiru from EmploymentLawyer.ca is answering your workplace questions. You can connect with his team at 1-888-861-4545. Email ask@employmentlawyer.ca or go to employmentlawyer.ca. Time for another question, this time from one of your live streams on Facebook and YouTube. My coworker was recently fired. Instead of hiring a replacement, their duties were shifted to me, forcing me to work extra stressful hours. When I asked about overtime pay, my boss simply said they would think about it.
I'm shaking my head here. There's nothing
Okay.
to think about. Remember, overtime is not a nice to have. It's not something your employer gives you if they feel like it or if they think you're a good guy. Overtime has to be paid by law. And in Ontario, if you work more than 44 hours a week, you get paid overtime. Anything over that is time and a half. That's true, by the way, whether you're an hourly employee or a salary employee. So you have to get paid overtime if you work it. Even if the company doesn't ask you to work it, but you work it because you need to get the job done, they have to pay it. There are some exemptions. For example, managers are exempt from overtime, but other people do get it. And if your employer won't pay it to you when they should, you can file a complaint with the Ministry of Labor, see how fast that gets resolved.
Okay, time for another scenario that your team has handled recently. My manager fired me yesterday because I arrived 10 minutes late to work once out of years of loyal service. I'm pretty sure she let me go because she's jealous of the praise my work has been receiving lately. Have I been wrongfully dismissed?
So remember, in the previous segment, I was talking about the fact that an employer can let someone go for no good reason as long as severance is paid. So this is not a good reason to let someone go, and probably not a nice thing to do, but it's not illegal. The employer can let this person go, even though they really shouldn't. Legally, they can, but they have to pay proper severance. What they cannot do is say, well, you were late, you don't get any severance. That would be nonsense. That is a wrongful dismissal. So it's not the termination itself that causes it to be a wrongful dismissal, is if this person didn't get the full severance that they're owed. And of course, them, as well as anyone else, can go to PocketEmploymentLawyer.ca, use the severance calculator to find out exactly how much you're owed.
Okay, Leora, thank you so much for being here today, as always. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca, visit cp24.com/Ask a Lawyer. We're back next week when we explain how severance pay rules apply to different jobs and situations. Thanks for watching.